Good evening, all, and welcome to this webinar on behalf of the Sisters-in-Law series. My name is Alan Frosch, and I am the co-owner and chief community officer here at Tattered Cover Bookstore in Denver. We're going to let people populate for just 1 minute, so we'll get started here in just a couple minutes. Thank you so much for being here. All right, as folks will continue to populate, we'll go ahead and get started. It looks like we lost Diane Gilboa from Theater Or, our partner. I'm sure she'll join in just a moment, but I want to make sure we're respectful of your all time. And again, thank you all for being here tonight. We're very proud of this panel we've assembled. Very, very accomplished group, and we're very excited for the conversation to begin. So we'll go ahead and dive in. Quickly, a couple reminders for this Zoom. First is probably best to view this in gallery mode, as there'll be conversation among the panelists. I want to make sure you don't miss anything in the exchange. Just one quick note: we are, of course, talking about the book Sisters-in-Law, written by Linda Hirschman. It is available at Tattered Cover. I'll include the links in the chat, along with links to the website for the play Sisters-in-Law, which is the reason why we've assembled this 5-part webinar series on behalf of the content provided. Again, we will also have a Q&A session at the end of this presentation. You all will see a Q&A function at the bottom of your Zoom screen. Please feel free to enter any questions there or use the chat function, and we will have a session at the end of our discussion. Again, we are so pleased to welcome this exceptional panel. Let me first, though, just very quickly thank the sponsors of the Sisters-in-Law webinar series. The League of Women Voters, the Colorado Bar Association, the Denver Bar Association, Boulder Jewish Community Center, the National Council of Jewish Women, Gibson, Dunn and Crutcher LLP, Tierney Lawrence LLC, Brownstein Hyatt Farber Schreck LLP, Universal Lending Corporation, the University of Denver Sturm College of Law, Mizell Arts and Culture Center at the J, the Colorado Women's Bar Association Foundation, and Colorado Attorneys for the Arts. Again, thank you all for supporting this very unique and exciting series. With that, it is my pleasure to introduce the Dean of the Colorado School of Law at the University of Colorado, Dean Lolita Buckner Innis, who joined the University of Colorado Law School on July 1st of 2021. We are very glad to have her in the state and running this beautiful institution. Dean Innis is an expert in feminist legal theory, in gender studies, and is an amazing contribution to this panel, which I will turn over to her now. Dean, it is a pleasure to see you, and thank you so much for being here.
Thank you so very much. Sounds like I got a little bit of feedback. Is my sound pretty good? Or? Okay, yeah. Excellent. So I am so thrilled to be here. It's just a pleasure and an honor to be invited to moderate this panel. I want to first start by introducing our panelists briefly, and then I want to have them introduce themselves a little bit, and then I want us to jump right into the conversation because that's why we're all here. First, let me start with our first panelist in alphabetical order, Essence Duncan. And Essence Duncan is a 2L student at the University of Colorado Law School, where I am so pleased to be the dean. So I am delighted to have you here. Next, I would like to introduce Arash Johanian, who is the Deputy General Counsel for the Denver Public Schools. And then after that, I'd like to introduce John Olufsen, who is a partner at the law firm of Lewis and Brisbois. He's also the Colorado Bar Executive Council member, or at least one of the council members. Thank you so much. So I'm going to go back and I'm going to start with you, Essence Duncan. I want you to just say a few words about yourself, and then I'm going to go back through in alphabetical order, and then we're going to start the conversation.
Good evening, everyone. I'm super excited to be here. As Dean Buckner Innis just said, I'm a 2L at Colorado Law. I graduated from Florida State University, and I'm a proud Floridian from a beautiful but questionable state. And I'm excited to talk about these justices today and their impact. Thank you.
Thank you.
Hi, everyone. So pleased to be with you all and with this esteemed panel tonight. Arash Jahanian, as the Dean mentioned, I'm currently Deputy General Counsel with Denver Public Schools, a role I've had since May. And then I was doing civil rights law on the plaintiff side for about a decade prior to that, including spending a couple of years at the ACLU. So I have that proud connection with Justice Ginsburg. And another, I think, connection to tonight's topic is many years ago, I clerked for the Honorable Wiley White Daniel, the late Wiley White Daniel, sadly, who was the first African-American federal court judge of this district. And again, his legacy lives with me every day, and I'm pleased to be here talking about the legacy of great justices.
Thank you.
Hi, I'm John Olufsen. I'm a partner at Lewis Brisbois in the Denver office. As the Dean said, I'm on the Executive Council of the Colorado Bar Association, and in that role, I serve as the chair of the Racial Justice, Equity, Diversity, and Inclusivity Task Force. I'm really excited to be here with everybody. Dean, again, welcome to Colorado. I hope you find that it's an amazing place and a place of growing inclusivity, which we love. So welcome to Colorado again. It's so good to have you here. So thank you for having me tonight.
Thank you so much, John. And John, you shared with us a few moments ago some good news that you just learned about an award. Why don't you tell us about that?
Yeah, I'm super excited, super humbled, a little confused, all of the above, but I was named as the 2021 LGBT Bar Association Attorney of the Year. So I'm really excited about that and excited about that celebration and really looking forward to the work to come still too, to be honest, because we're not done yet. In fact, we've just started. So, but thank you. I'm really excited about that.
Thank you. So I really want you all to just sort of jump in and share some of your thoughts. I will start though with some of the things that come to mind for me when I think about Justice Ginsburg and Justice O'Connor. For me, growing up, certainly there were relatively few women role models who were serving at the highest levels like these women were. And one of the things that particularly strikes me and struck me going back years from when these women were on the bench was that these were women who were, on the one hand, non-traditional in terms of how we thought of women in the 1950s and yet traditional. So both of these women were born in the 1930s. Both of these women came from parts of the country that were not necessarily thought of as sort of the heartland. I mean, Justice Ginsburg was from Brooklyn, New York, and Justice O'Connor was born in El Paso, Texas, and spent a lot of her childhood in the Southwest in Arizona. And so in those respects, they were sort of a little bit, I would say, outside of the culture. But one interesting thing about them is that both of these women married quite young. They both married in their 20s. One of them married right out of undergraduate school and then went to law school with a spouse. And so as someone who, like me, has looked a lot about feminist legal theory, it strikes me that one of the things it means when you talk about feminism is not just focusing on women, but also focusing on men and the men who helped to these women to get where they were. So I guess I would say, I cannot imagine either of these women doing the things that they did, having children, indeed, right along in their youth as they worked to climb the ladder in the legal field. I wonder if you want to say anything about that and sort of what comes to mind when you think about women justices and sort of forging a role as both traditional and non-traditional.
I can go. I think about this a lot, especially being, a law student and kind of embarking on my law school career and being a woman. I remember the first things that I thought about when speaking with other, women attorneys is that, you have to be strategic with when you want to start a family. That's one of the first things that I kind of had to learn about, which, to be honest, made me sad about that, is that I'd have to, either put something off or, let something go in order to have a family, which is important to me. And so I think that it's interesting, that observation of you kind of understanding what that would have looked like if they did have their families already, and would they have been able to trailblaze as much as they did. And I think the truth is maybe not. I think that they may have been looked over for a lot of things because they had to prioritize their families. And I think that's something that a lot of women in this field can relate to, or are going to have to eventually.
What I really liked, Dean, is that they were non-traditional. They weren't just a bunch of straight white guys sitting up there in black robes. Much like you growing up, I grew up in an era in the 80s and 90s where I saw constitutional amendment after constitutional amendment going against the LGBTQ community, which I'm a part of. And when you're 12 years old and seeing that, it's a little scary. And by a little, I mean a lot. And you feel really alienated on an island. But to see these two women go to the top of their profession, to the top of our government, and they're not just straight white guys wearing a black robe, was really uplifting, even for a man. Even for, for me, I thought that was really groundbreaking. But for me, it just gave me some hope that even someone who didn't just look like a straight white guy in a black robe could make it. So I found that to be really inspirational.
I'm trying to think of what I can add to what's been said, and John very much actually identified kind of where my passion for LGBTQ rights emanates from, which is a similar experience over a similar time frame, seeing state constitutions amended to take away people's rights. But I think that's a little bit of an aside. When I think of groundbreakers and trailblazers in the way that these two justices were, first off, I'm reminded by the RBG quote of when there are nine, which is, I think, absolutely the right answer. And with so many institutions, especially at high levels, it's disappointing how things lag behind. I am ashamed as an American that we still haven't had a woman president. But you have to still, Dean, as you kind of did in your opening remarks, acknowledge the roles that each plays in breaking ground at each level and getting to where we need to get, which we still have a long ways to go. I think it's interesting to me, and when I was kind of reflecting and preparing for this panel, in that although Justice O'Connor was the first, and maybe this is a recency thing, maybe this is a generational thing for me, Justice Ginsburg's the icon, right? She's the one who has her face on t-shirts. She's the one who has my neighbor, 2 doors down from me has an I dissent flag with, honoring Justice Ginsburg. And so for me, there's a couple questions there. One is the extent to which O'Connor paved the way for RBG to be the way she is, by being kind of not ruffling feathers and not showing up, being the first woman and really trying to shake up the institution. And I don't know if this is a fully apt comparison, but I'm a huge baseball fan, and one of my favorite historical figures of all time is Jackie Robinson. And I actually think about how Jackie Robinson was very much asked to, just be that person who kind of goes about his business quietly and takes abuse after abuse after abuse. Later on in his career, actually, he started to become more outspoken and started to receive criticism. So even though we think of Justice O'Connor as this kind of a more conservative figure, as one who wasn't willing to push the envelope as much, and one who, as a progressive, and I'll get into this a bit, disappointed me in some ways, was her kind of approach of kind of being more acceptable or not, as I said, ruffling feathers. Did that kind of pave the way for RBG to come in as the second woman on the court to then to find her voice and be able to express herself?
I really like that, Araj. I have to tell you, I have to brag. I even have an RBG planter. And of course, I put aloe vera in it because it's healing. But you're right. She is the icon, right? It's not just T-shirts and flags. It's little planters. I mean, you're right. She is the icon. But if you look at Justice O'Connor and you talk about kind of paving the way for change, I think there's a transformation in O'Connor as well that you saw during her time on the bench. And it makes you wonder what was next. Like, what if we could have kept her? What was next? So you look at the Bowers v. Hardwick decision back in the 80s. In the LGBT community was like, oh crap, here we go, right? This was the first big decision, and Justice O'Connor came out in a way we hoped she wouldn't. So when Romer v. Evans, which is near and dear to our hearts here in Colorado, with the Colorado Amendment prohibiting municipalities and governmental entities from providing protection to the LGBTQ community, people were nervous. The LGBTQ community was nervous. And then here she comes, siding with the majority that said, no, Colorado, you went the wrong way. And then a couple years later, you get Lawrence v. Texas, where she writes her concurring opinion that went from the 5th and 14th due process over into equal protection. And that was great. And then you're like, there's progress. But even in that opinion, she kind of lets you down at the end when she's like, but there might be a rational reason for heterosexual marriage preempting. And you're like, oh, well, 2 steps forward, 1 step back, even in one concurrence. But then, she was really pivotal in moving the cause forward with only 2 big glitches, and that's with the Boy Scout case and, of course, with the parade case, the St. Patrick's Day parade case. But she was a pretty good vote in favor of LGBT rights. And, of course, then there's Southeast Pennsylvania versus Casey. And so you see these glimmers of hope. So you kind of see a progression with just her on her own, moving into a really moderate to progressive-ish voice. Then again, we get into Michigan where she's like, well, we won't need affirmative action in 25 years, which I guess is wishful thinking at the best. But you see kind of a progression there. But then you get, Justice Ginsburg come in, and boy, was she a solid vote. And her dissents were incredible. Her dissents paved the way for legislation. When she sat on the bench and read her dissents to make sure they got more attention, I guess maybe, Raj, you see progression both with O'Connor and then with Ginsburg kind of picking up that mantle. So I think it's a really interesting progression in general.
Wow, those are great comments. I mean, I was struck by what we just discussed, and it sort of suggests that on the one hand, I think both justices would have described themselves, interestingly enough, as apolitical, and yet we see that many of their decisions are often embraced by particular political communities. What does that mean for us? I mean, was it ever fair to say that we have an apolitical Supreme Court? Certainly that's the goal, right? This whole idea of these justices who are going to serve for life and who, as you just suggested, John, they have evolved over the years, many of them. Is this largely apolitical? Or what are we seeing here? How are we supposed to think about this? I mean, I'm really intrigued by it, especially, of course, in light of what's gone on recently with the Supreme Court, right? I would love to think of them as an apolitical body. However, I'm not sure if it is if it makes sense to do so.
Yeah, Dean, I agree with you. I think, I think I come from some similar legal schools of thought as you do. You describe yourself as a feminist scholar. I basically say that I minored in critical race theory in law school. So I think saying that, trying to canonize judges as being apolitical figures, I think is a false exercise. That said, I do think part of what we've been discussing in terms of O'Connor maybe being more restrained, or at least what I expressed in RBG being more outspoken, reflects in some ways the evolution of the court. I can't say that I followed this super closely, but I think all justices were more restrained, on the court on which O'Connor sat. They weren't out there making speeches as much. They weren't out there expressing themselves. and when we think of RBG's legacy, and which I think for a lot of folks is an overwhelming positive one, I think there are some regrettable moments there. For instance, her commenting on then candidate Trump, and that's, I think, a reflection of some of the more public comments she was willing to make. But to, I guess, kind of provide a short answer to your question, I don't think it's ever fair to look at justices as apolitical and in an apolitical manner. And I think, John, one of the cases that I think about was Lawrence v. Texas, which overturned Bowers v. Hardwick. And, Justice Scalia's dissent is one I will never forget reading, where much of law school for me, I'm reading Scalia's opinions and I'm thinking, I disagree with you, but man, your reasoning's good, your writing's good, I'm having a hard time. I know I don't like the outcome of this case, but I'm having a hard time disagreeing with you. On that one, I think he just showed his colors and showed his anti-LGBTQ bias. He just did it. And so I think that's one example of that. So anyway, I think, sorry, I said I'd provide a short answer, which is that I think it's never been an apolitical body, but I think it's more evident now than ever.
I completely agree. And that's exactly the answer I was going to give, right? Is that it's never been apolitical. I mean, they're appointed by political parties, and the decisions that they make are incredibly political. I mean, there's no way, I think, to be neutral on the bench as much as they would hope to be, because they are human beings. They're appointed by certain people that they support, and the decisions that they make affect the politics of our country. And so it's not that way. It's not apolitical, even though I think the system meant for it to be.
Well, and I think back even when they were on the court, the Bush v. Gore decision, which I read that opinion even today. I was in law school when that was issued. I read that opinion today, and it's a head scratcher for me, that the only way I get there logically is say, well, they sided with their guy. It's hard for me to get there any other way when you read the decision. And so to Essenson's point, it's hard to look at them as apolitical. When that question's asked, the first thing I go to is Bush v. Gore and how that all came down.
Wow. I sort of flinch when you say they sided with their guy, because, it's funny. I tend to describe myself, though certainly a lot of my work would probably characterize me as fairly progressive. I'm also what I would call a cynical optimist, meaning I desperately want to believe in an apolitical court. And even if it doesn't exist or hasn't existed recently, I'd like to imagine that we could get there someday. And I also suspect, and I think Arash may have mentioned this, I suspect that for Justice, for example, O'Connor, I think that there was a culture in which she was mired. I mean, I think as someone pointed out, she's the only person still alive who served on the Burger Court. I mean, what could that have been like? In terms of being expected, I think, to suppress certain ideas and ideologies about not just the cases themselves, but about judicial decision making. I mean, that there are ideologies about decision making that I think judges embrace, whether or not it might reflect their own thinking. I mean, and is that a good thing or a bad thing, to put it simplistically? I don't know. I don't know.
Well, but then you look at O'Connor when it comes to Romer v. Evans and Southeast Pennsylvania, and she did not toe the party line there at all. In fact, was it Romer? No, it was Lawrence v. Texas. She got a lot of wrath for her concurrence in that from the right wing. A lot of wrath. What a turncoat. She wasn't here for us. Of course, she was a big vote on Romer v. Evans and turning that over, which was a huge pivotal case for the LGBTQ community. And then, of course, her role in Southeast Pennsylvania and women's reproductive rights was huge. So, I mean, to your point, in your idealism, in your optimism, I guess there's a lot of examples, but with our two right there, I think those are examples of apolitical and following what they thought the Constitution said and following their beliefs of equal protection and due process, which I think is really important.
And Dean, I don't mean to suck all the optimism out of you and out of everyone. I mean, I do think there are signs. I think there are 9-0 decisions that still come out. I think certainly we could get off on a huge tangent and talk about Justice Roberts and Chief Justice Roberts and how he sees his court and his role, and his votes on the Affordable Care Act, his vote on the just to dissent against this Texas anti-abortion law. But I think maybe I've been reading too much political commentary that is saying that Roberts is losing his court, and yeah, it's certainly an alarming time in the court currently. But I do think there are signs of hope, and as with a lot of things, time will tell.
So I'm wondering here, well, I guess looking at these two women, and especially looking at the times in which they served on the court, do we think, and I think we've already talked about some of the cases that were sort of emblematic of their work, are there particular cases or parts of cases that you think sum them up, given that over the course of their years on the court, they've been some directions that seemed incredibly far apart? I mean, is it fair to, or are you able to characterize their work, for example, as progressive or conservative? Because that's the way, for example, people like to describe the difference between Justice Ginsburg and Justice O'Connor. And I just don't know if that's true. And at least I like to, going back to my optimism, I like to hope that it's not true, but maybe, especially looking at some of their iconic cases, maybe there are cases that really sum them up succinctly. And I wonder if you might speak to that.
One that sticks out in my head for Ginsburg is Ledbetter. And the reason why is because the passion she wrote her dissent. Of course, we all, I dissent. The dissent, Ruth Bader Ginsburg, she's known for it. But for me, that was Justice Ginsburg in a nutshell. Because that and the voting rights case. The umbrella case, just because you're sitting under an umbrella not getting wet doesn't mean you get rid of the umbrella line. Those two right there define Ginsburg, because she was vehement, she was passionate. In the Ledbetter case, she spoke about it. Of course, then it was the first piece of legislation signed by President Obama, and many people credit her reading her dissent from the bench and making it a big deal into one of the big catalysts for that change to Title VII. So I don't know. I like that. And then, of course, I thought she was particularly vocal when she was talking about the Voting Rights Act and the states that had to maintain their preconditions. And when they got rid of that, she was like, just because you don't think there's a problem now, it's because we're holding the umbrella. To me, that was her saying, you got it wrong. And I think those, in my mind, are two iconic Ginsburg moments.
So to piggyback on what John said, I think you can question the role of dissents and the effectiveness of dissents, but I think the two examples that John gave, and then also to me the Hobby Lobby dissent as well, where Justice Ginsburg, I think what dissents accomplish, and particularly what Justice Ginsburg was able to do, was put everyone on notice. Put the court on notice, to put government as a whole on notice, to put society on notice. So when we see voting rights being chipped away at currently, that line keeps popping back into my head. See, this is what Justice Ginsburg was talking about. The Voting Rights Act, as was implemented at the time, was working, and here is how, through the Shelby County ruling, how things are being chipped away at. With Hobby Lobby, where, and Hobby Lobby was a case where the religious exercise of a corporation was recognized essentially for the first time in being able to deny coverage for contraception under the ACA. Her dissent warned us, is like, we got to be really careful now. And the court is going down a very dangerous road where it comes to religious exemptions. What's next? And John, in preparing for this panel, one of the cases that we talked about that's been so impactful for him and for a lot of us is the recent Bostock opinion. And by the way, Dean, this is one of the cases that can give us hope, right? Justice Gorsuch writing a pro-LGBTQ opinion in a 6-3 case where Roberts joins the majority as well. So in that, decision, what people may not be aware of is that Amy Stevens, one of the plaintiffs in the 3 cases that had joined, she had lost in the lower court. And the lower court judge had actually cited Ginsburg's dissent to say, you know what, she was right. There is a religious exemption here to Title VII. These people can discriminate against trans people. And it was like, oh no. And I think by doing that in the lower court, that also helped put the Supreme Court on notice and say, no, we're not taking it that far, right? So I think that helps to demonstrate the power of the Ginsburg dissents, and not just as this kind of cultural phenomenon, but really as being something that's effective. Diane's asking us to explain the cases. No, you didn't miss the explanations. We're doing too much lawyer speak here. Shelby County, and maybe someone else should do this, but Shelby County said that part of the Voting Rights Act had basically run its course. And so there weren't certain requirements imposed on certain voting districts. So they could basically get away with more than they had prior. And I'm going to let someone else who would like to try to explain that better than I just did. And I think I tried to explain Hobby Lobby, and I'm now blanking on the third dissent, so I won't even go there. If I can shift to talk about O'Connor for a bit, and there's actually, there's one thing she did in particular that has had an impact on me, and I think we all have to, again, see this through a very personal lens. So growing up a religious minority in this country, I have always been very sensitive to society and the religious symbols that I see in it. And the Establishment Clause is actually the first piece of the First Amendment. And that's essentially the separation of church and state. And Justice O'Connor, in a case about a nativity display on a piece of public land, she developed a new test for when the Establishment Clause is or is not violated. And it's called the Endorsement Test. And I actually was so affected by this that I wrote 2 separate notes about this in law school. And so she said, that this is violated. I'm actually reading from my note here. This is violated if the government's actual purpose is to endorse or disapprove of religion, or if the practice under review, in fact, conveys a message of endorsement or disapproval. As she said, endorsement sends a message to non-adherents that they are outsiders, not full members of the political community, and an accompanying message to adherents that they are insiders, favored members of the political community. So this is beautiful language. I'm thinking this is great. And then what does she do? She goes on and says, oh, this nativity scene doesn't send a message to anyone. It is just part of our history's secular symbols. And I think it was Justice Brennan in his dissent in that case, he was like, what are you talking about? This is one of the foundational events for all Christians, the birth of Jesus. How can you say this is a secular symbol? So to me, that kind of symbolizes O'Connor in that she gave me hope, and yet she let me down kind of at the end. And again, given my philosophy and my personal experience as a religious minority, she was like, well, let's look at this from the eyes of a reasonable observer or this neutral person. And if you have, Dean, kind of going back to your what's a realist versus ideologue kind of, not ideologue, but idealist kind of perspective on the court, you can't take real experiences out of that. What is someone like me or someone who does not identify as a Christian, what do they feel when they see a nativity scene? And that test has been applied, time after time in ways that have disappointed me personally and that I think are wrong. I think the test is a good one, but I just think the perspective that it's been applied from are unfortunate. And so for me, that's an embodiment of O'Connor. It's this, she did some great things on the court, but just couldn't quite get far enough for me.
Essence, I want you to jump in here. We just talked quite a bit about dissents, and I'm wondering about your perspective as a law student. I know when I was a law student, and certainly as someone who very recently has been a law professor, especially for 1L students, one of the things that we try to inculcate in students, with this think like a lawyer is, well, you really need to care about the main decision. Dissents are very nice, but honestly, you're making a mistake if you, for example, try to rely upon dissents when you're writing briefs, et cetera, or when you're looking to support your work. So on the one hand, we still keep telling our students, yeah, dissents are nice, they're very interesting, and if you have nothing else to rely upon, go ahead, but frankly, they're not worth much. But I think we've just heard, I'm sure you've seen now as a student, dissents can mean everything. I mean, what are some of your thoughts about that as a student?
No, I definitely agree. And I was lucky enough that I had a Professor Helen Norton. She's so amazing at CU Law, and she hounded on dissents. She hounded on those. And I remember when I, first in the beginnings of con law, I was like, why do I need to read like the one when they didn't win? Like, what's the point?
Yes. Yes.
Stick with the majority. But as I started to get into it, I started to really realize the importance of that and why we were reading them. And it wasn't because, the majority opinion, that's what stands, but the dissent is important in the way that they logically thought about everything and argued the law. And also, even the dissents were a lot of times comforting. For me, I'm Black, I'm a woman. And so there were a lot of cases that I had to read in con law that directly went against my humanity. Right. I remember reading one case, and I wish I remember the name of it because it made me so angry. But it was a Black man, and he was asking the Supreme Court if he could be a citizen because his father had built parts of the country. And so he said, well, I think that Black people in the United States, if they are descendants of slaves and slaves built this country, then they also deserve citizenship because they helped basically the process. The Supreme Court was like, no, I don't think that's the case. That's not good enough. Like, you built it because you were a slave, not because you were a person that we cared about. And it's that simple. And the dissent actually went into talking about, where's the line, right? So we're saying, like, when we really think critically about Black people in this country, we forget that they really did help us build this country. This is the first time we've, had to think about this. And instead of listening and using this as a way to open our arms to this community, we've decided again to kick the door in their face and say they're undeserving of the rights that we have been born into and enjoy on a daily basis. And so that was one of the things I remember being so angry about reading that case, but I got to the dissent and I was like, thank you. I was like, thank you for validating me, because I remember reading, I'm like, of course this guy's going to win. Like, this makes complete sense. And that wasn't the case. All right. It's a very, very old case. And so the dissents are, I don't want to say more, but equally as important as the majority opinion, because the things that they're talking about, like we've said, RBG's dissents have, led legislation and changes. And so I'm so happy to know that there's, so many justices and Justice Ruth Bader Ginsburg and O'Connor that were willing to speak up, on different things in dissent. So the world can see that. That's important.
Well, and on the same token, concurrences. Yeah. So with Justice O'Connor and her concurrence in Lawrence v. Texas, I think she really foreshadowed the whole equal protection theory for protection of the LGBTQ community, which to that point was saved for people of color and for women. And she opened the door in her concurrence that I think really started, and not that the majority in that case wasn't great. Due process under the 5th and 14th is important as well. But let's be honest, that equal protection analysis has just that little bit more teeth, a little bit more staying power and a little bit more teeth. So even in that case, with the concurrences, I think are super important as well. In essence, it's been a couple of years since I've been in law school, 1 or 2. But you're right. I was the same way. I'm like, do we have to read this? It's extra. I have contracts I have to do. I have torts. But really, constitutional law and reading opinions from our Supreme Court is foundational. And I think these dissents and concurrences not only foreshadow maybe the future, but give us groundwork for future law and future opinions when the court changes. Now, that's not always good, I'm nervous about a few things with this court. So, I mean, it's not always good, but I think in some cases it's important.
Just very quickly to John's point about concurrences, the case I was talking about where Justice O'Connor established that endorsement test for the establishment clause, that was in a concurrence. The case was called Lynch v. Donnelly, and then in subsequent cases, more and more justices you see adopting that test, and now it's well established today.
No, I think these are wonderful observations, because I think like all of you, when I was in law school, it wasn't that I was unwilling to read concurrences or dissents. I think that, well, and I think since you mentioned this, you were very lucky to have Professor Norton. I think professors, they seem to be speaking two languages. You know, on the one hand, you know, we care about majority opinions. When you're trying to write your briefs or you're trying to argue, you certainly need to look to those. However, very often in the classroom, you know, we're parsing those concurrences and those dissents, because I think, as you said, John, these are often the roadmaps. These are the ways in which we have a sense of what's coming. So I think, for example, even if we may look with a lack of ease about where we might be going in some contemporary cases, I think it's helpful to know. I mean, I think it's helpful to be able to parse a lot of that language and say, okay, here is where we might be heading. And so that brings me back to, for example, someone like Justice O'Connor. And again, I think certainly when I was a young lawyer, I definitely thought of her as, oh, yes, that's nice as a woman on the court, but she's definitely strongly conservative, both in her personal views and in her jurisprudence. But I think, as we've discussed, that's not necessarily true. And we only know that because we have been able to parse many of her decisions, you know, and that's true whether she wrote the majority or she wrote a dissent. And even when she wrote decisions, sometimes I wonder how much did she believe it. So I think, for example, we were talking very briefly, alluding to the Grutter and Gratz cases, the University of Michigan cases, where we're talking about affirmative action, where Justice O'Connor seems to say, well, you know, in 25 years, and what is that? We haven't gotten there yet, but we're soon we're going to reach that period of time. We're ticking off the years. I think we still have significant issues around racial equity, not equality, but equity in our school system. I think she may have recognized that, but I think also there was an extent to which she was someone who wanted to carve out a space so that more people could agree with her. And I think, and maybe that was just a style of jurisprudence. I don't know. I mean, because surely she understood.
You'd think, but let's be honest, one of O'Connor's biggest gifts was her vote. Whether she wrote the opinion or a concurrence, was her vote. And her shift as her tenure went on in Romer v. Evans, Lawrence v. Texas, Southeast Pennsylvania, right, in the plurality in that case. I mean, it was her vote. And the fact that she was there and she pivoted, if you will, not that we always loved some of the things she wrote. She, like we've talked about a couple times, she kind of, Justice O'Connor giveth and then she taketh away in a few different instances. But in Ginsburg as well, she didn't always write the opinion or the dissent, but she was a vote that was really critical. And I think, speaking of dissents, didn't Ginsburg actually say, was it about her Hobby Lobby dissent? She's like, I did that because I think it is the law someday. I think this will be the law someday. It might have been her Hobby Lobby dissent, but I can't remember. But she's like, this will be the law someday. And she spoke about it frequently before her passing. Plus, I have to make this, Justice Ginsburg was the first Supreme Court justice to do a gay marriage, to perform it. Justice O'Connor was the first Supreme Court justice to do it in the Supreme Court chambers. So regardless of their jurisprudence, regardless of their writing, their actions actually spoke as well. And of course, Justice O'Connor was a well-known socialite in DC. She and her husband were all over town. Like, they were at all the events, and apparently they were super funny, super engaging, super inclusive, but they were always in the know, which I think is fascinating, right? Because you kind of think of Supreme Court justices as hiding away and reading their books and, you know, being insulated from everything. But all the stories from O'Connor and her husband John were that they were social butterflies and they were in the community, which I think is really fascinating as well. So, I mean, we look at their decisions, we look at their work on the court, but let's look at what they did outside of the court. And both of those women actually did really inclusive things and were really part of inclusive things that were, that they led by action and actually doing and showing up and engaging, which I think is really important as well.
I think one thing about, Justice O'Connor, I think that shift back and forth is pretty clear, right? Because I even remember, reading about her confirmation hearing and when she was asked about her views on, abortion. And for her, she was able to say, it's a personal matter for me. I don't approve of it. That's not something that I want. But I also know that I'm a woman I've already, gone through the hurdle of, pregnancies and those types of things. And so me not allowing those decisions to be made by women who are in that place could be detrimental to them. And I think that's so powerful. I think that's one of the things that you'd hope that justices would have, right, is that being apolitical and saying, I don't agree with this. Personally, I don't feel this way about this issue, but what are we doing for the citizens? How would this affect women? How would this affect people? How would this affect those that this legislation is discussing? Because they're discussing human beings' lives at all times. It's not always just politics. It affects real people. And I think that if politics aren't affecting your life, then that's a key and that's a privilege. Right. And so they're really, debating lifestyle and humanity in this country. And so that was one example of her that I enjoyed to see, as her way to kind of be ambivalent and say, I feel this way, but I understand that I need to care more about my opinions and about how it's going to affect everyone else.
That's something that you just raised, and I think this is comes to my mind after what we just discussed about the differences and yet the immediate similarities between Justices O'Connor and Ginsburg. I'm wondering, what do we envision about the women who are currently on the court and their status as, quote, sisters-in-law, right? So we've got the latest woman justice, Amy Coney Barrett, we've got Sonia Sotomayor, right? And we've got Elena Kagan. And I personally have been to lots of events where I've had the privilege of seeing Justices Sotomayor and Justices Kagan. I mean, they often hang together. They seem to be friends to the extent that we define friendships from just public view. But what about Justice Amy Coney Barrett? I mean, is there ultimately, do you envision that there's still a sisters-in-law relationship between and among them? And what will that look like when we're looking back, as we are now, about two women who've served on the court in the past? I'm just really intrigued by it.
That's a really hard question, and I have a lot of responses to that I need to put through the filter, and those who know me know that the filter isn't always there. But my concern with her is
Amy Coney Barrett, that is, or
correct, yes. My concern with her is she going to be like an O'Connor? Is she going to be thoughtful about the Equal Protection Clause, about the 5th and the 14th Amendment? Is she going to step back and give it that same consideration? I mean, for a long time, jurists would argue before the Supreme Court, and they'd say, we're arguing for a justice of one, and they'd be talking about O'Connor. My question is, do I believe she fits that type of a role? And my gut feeling right now is no. But again, we're new, right? It's all new, and I may be super wrong. But with the Texas abortion statute now on the books, that's going to hit the Supreme Court, and it's going to hit it big. Do I wish Ginsburg and O'Connor were there? Yeah, quite a bit.
Well, and I think we have to talk about reproductive rights today. I think I don't think you can talk about Justice Ginsburg's legacy without talking about reproductive rights. And because it is such a current, powerful, recent issue, and it can't be the only thing we look to, but John, you have that gut reaction to Justice Barrett. We have one glaring example of how she's not going to be like a Justice O'Connor. And it's unfortunate. And Dean, I don't know how to answer your question about the relationship between Justice Barrett and Justices Sotomayor and Kagan. although I see some parallels there potentially, you know, I had the pleasure of seeing the play on Saturday night, so it's fresh in my mind, and it's really about how two women who didn't necessarily see eye to eye on either the approach of being how to be a justice or ideologically, nonetheless saw a set of kinship might be the wrong word, but a commonality in their experiences and how they needed each other as allies on the court. And I don't know that that's true anymore. And that may be because of the ground that Justices O'Connor and Ginsburg broke for the current women on the court. The much easier question or thing to talk about is how it does seem that Justice Sotomayor has taken the mantle of being that vociferous dissenter, and providing some really powerful dissents. And I mean, several cases already come to mind that I think I'd be going down a rabbit hole if I tried to talk about them.
No, I think for me, I mean, to be quite honest, I'm nervous. I think that's something that I was, thinking about when watching the confirmation hearings is I was nervous about that. And I know that, in the Black community and especially in the South, there's a saying where it's all skin folk ain't kinfolk, right? And so that means that not everybody that looks like you or identifies the way you do will support you when they make it to a certain space, or will vouch for you once they get through the doors, the barriers that you've tried to break. Some of them will shut the door in your face when they get there. And so I think that I'm definitely hoping that with Amy Coney Barrett is that she kind of does have that smooth transition, kind of like O'Connor did, where, there's personal opinions that come with being a human being and being in this country, but moving to becoming a justice and being in charge of, again, humanity and people's lives and the way it's affected. You think more broadly and you leave that box and that tunnel vision of personal views. And I really hope that happens.
Really quick, Dean, when as we were all discussing this, the one thing I thought of talking about this isn't something that's just in a textbook. It's not something, this is real life application. We're talking about real concerns and real life. And I just heard it from you right there. And I'm in that same boat, right? Like I'm nervous that we are still people that have the Supreme Court deciding our fates. And we're still in the thick of that. We're still in the middle of that. We still need to think about that every day. Like, what's going to come from the court? I mean, I'll never forget where I was when the gay marriage case came out, right? It's marriage, but for ease of conversation. I cried. I was in a parking lot of a doctor's office getting an x-ray, and I cried when I heard the news. This is real life. It's not academic. And the more we talk about it, the more, I want to solidify that this is real life. It has actual applications to things that we do every day.
Mm-hmm. Well, with that, we have a question in the chat that maybe swings quite the other way from what we've just said. What is real life? One person asks, how do we think about then cases that rely upon things like the quote intent of the framers, close quote, right? I mean, in some respects, it's deeply concerning that we may be relying upon people who wrote in the 1700s and sort of expecting that they would have envisioned many of the problems and concerns that we have now when it comes to constitutional interpretation. Is there any room for intent of the framers in a fair, just and neutral approach to any of these cases that we've talked about? Is there any room for that?
I mean, I'll jump right in and say that I don't think so. I think we're modernized and we're way beyond. I mean, a lot of the framers, they didn't think I was competent because I'm a woman, and they didn't think I was human because I'm Black. And so I'm not comfortable with going with their intent and what they wrote because they had me in mind, not at all. And so that's definitely something that I have a pretty strong hold on because of my own identities. And, I'd love to hear from Arash and Donna what they think too.
I'm kind of with you on that. It makes me nervous. They're a bunch of straight white guys. I mean, look at the Bowers v. Hardwick decision. They were a little weirdly obsessed with gay sex. Let's be very honest. I was actually in a room hearing Justice Scalia speak back probably about 12 years ago. And someone in the audience asked him, Justice Scalia, what do you actually know about gay sex and the framers and what they did? And he kind of got quiet. And It was 1,000 people in the room in the Lubbock Coliseum. It was in Lubbock, Texas. And in fact, at one point, he's like, I thought I would have a welcome audience here, and he didn't. The room went quiet and waited for what he said, and he didn't have much to say about it. So is there room? Sure. In circumstances. Like, I'd love to hear, I like to look at what the Federalist Papers had to say. I like to see where their decision tree was going, but yeah, I'm SM with you. Like, that's a real narrow perspective that doesn't reflect our country today at all. So it makes me really nervous.
Yeah, I don't think anyone here will be surprised at essence when I'm saying I think there's some room, but to turn and trying to strictly look at the frame the intent of the framers as, and by the way, your comment earlier made me think of Justice Thomas more than anyone. But I think that's just an unfair exercise, and the example that I point to is exactly what you said, Essence, which was written into the Constitution. So white male property owners, straight cis is who those framers were, and that's not our nation. And so why are we looking to Barrington?
Although they did wear wigs and high heels, so RuPaul might give them a pass, but that's a different story.
That's so interesting. Totally off topic, but a little bit related. I saw an article today that said that early Supreme Court justices actually wore colorful red robes with gold trim. And I saw some pictures of them and I thought, wow, things have really changed sort of from a fashion perspective. We have another question from an attendee, and it's about the Hobby Lobby case. And this person is wondering, how is it that case can seem to deny rights seemingly on any basis? I mean, do people have rights or not in this kind of context? And I wonder if any of you want to take that on.
Well, I think Justice Ginsburg captured our fears with that case. And some of the factors that, and it's been a while, frankly, since I read Hobby Lobby, but some of the factors that the majority looked at was that Hobby Lobby was a closed corporation, and this family kind of embedded its religious beliefs throughout kind of everything it did. Like, you looked at the company bylaws and that kind of thing, and the religious intent or beliefs of the company were expressed through that. And part of jurisprudence in the kind of religion context is you can question the sincerity of someone's belief, you cannot question the validity of it. Mm-hmm. So when the owners of Hobby Lobby in this closely held corporation said, we, as Christians, do not believe in providing contraception to our employees, the Supreme Court's view is that we kind of have to take your word for it. Now, I believe that was a 5-4 decision, and what Justice Ginsburg is saying is you are opening a gaping hole here. And I think, when it comes to the Supreme Court's jurisprudence, and, you want to talk about Masterpiece Cake Shop, which is, I think, for, again, coming back to LGBTQ rights, which John and I and many others are especially passionate about, that was like the big case. And it's not gone yet, because that really was a punt by the Supreme Court, but they did rule in favor of the baker. They did not get to the question of, is there a broad exception to LGBTQ rights whenever someone has a sincere religious belief? And in fact, Justice Kennedy, in that written opinion, did provide some really strong support for Colorado's anti-discrimination laws that protect the LGBTQ community. So there was a lot to see in that, but they have not arrived at that issue, and one day they will. And I can't remember which case, whether it's the photographer case or another baker case or what it is, that's headed up to the Supreme Court. So they will get to that issue. So there's, as with any annoying lawyer, I can't give a direct answer to that question. There's a lot of gray area, and frankly, there's a lot of fear. I think the Hobby Lobby case was cause for a lot of alarm, and both from perspective of legal advocates, and when I say legal advocates, I'm talking about folks who have tried to exploit that hole that they're seeing in anti-discrimination law. I think there's a lot of fear there, and I think there's also legislators who have continued to try to chip away at rights using what they call a religious exemption. So that's a great question, and I think it's a battle that's going to be fought for years to come.
Mhm. Mhm.
Talk about framers' intent. Do you think the framers intended for these type of rights? Were they concerned about multinational corporations and their religious views? My guess is probably not. But here we are, right?
Right, right. But here we are. And we've got just a couple of moments left. I'm wondering if any of you would like to sort of offer some closing words about anything that we've talked about today. Any thoughts that you might not have had a chance to share yet?
And I can just share my, last words. I think one thing I was thinking about when coming onto this panel, right, is just the doors, that have then been kicked down by these women, and kind of thinking about me and in my life, being a baby lawyer, I'd say, being in law school, right, and going into the legal field, what ways that I can do the same. I'm easier, I have an easier path because of the things that they've done already. And I think that doing the same in my career is something that I strive to do, no matter how small, even if I only kick one door in, or, if I kick a double door in, I don't know, but, something to make sure that the people coming after me have it a little bit easier than I did. And I think that if everybody has that mindset and keeps that progress, the world can honestly just go on forever. And there's so much that can be done, and equity that could be reach in this country. So I'm excited to be a part of that once I join the legal field.
Dean, I've said enough this evening, and frankly, I'm more interested in your closing thoughts than anything else, and John's, of course. But I've said plenty, and I just appreciate the opportunity to be part of this amazing program and panel. So thank you.
Much like Raj, I've talked too much, but no surprise there. But my big closing remark is Supreme Court decisions, politics, all of these things we're talking about are not something just for TV shows on Sunday morning. They're real life. They affect real people. Before you get all excited and get on your soapbox, talk to someone that it impacts, and hear and listen, and really pay attention to what you're hearing. Because just because something isn't your experience doesn't mean it isn't a real experience at all. But thank you, Dean, for hosting this tonight and keeping us sort of on track as much as you can track Legal Minds, which is nearly impossible. But thank you very much.
Well, thank you all. This was terrific. I guess one of the significant things that have come through to me as we've talked tonight is just this sort of notion that they talk about in leadership. The idea that there will be times when you have to listen carefully, be willing to say, I deeply disagree, and yet still have to say, but I concur in what the majority is doing. And I have to say, for me, as a new dean, that's perhaps one of the most difficult tasks that I will have. But I do think about people like Justices O'Connor and Ginsburg, and I'm sure there were times when they've had to do that. So these women are, for me, and I'm sure for all of us, just tremendous, tremendous models of how to do this work, how to undertake the legal enterprise.
Wonderful. Thank you all so much. Dean Innis for moderating. To our panelists, Essence, John, and Arash, thank you all so much for your candor, for your thoughtfulness, for your vulnerability. We know these are very personal topics, talking about the legal legacy of these individuals and our country in general. It's a really thoughtful conversation. We're very grateful for your time this evening. It is my pleasure to introduce our partner from Tattered Cover, our partner at Theater Or in terms of this webinar series, Diane Gilboa. We'd love to talk about the play itself. And Diane, I'll turn it over to you.
Well, thank you so much. Sorry to miss you at the beginning when my internet connection evidently was a bit faulty, but I'm so thankful for all of you to have volunteered your time for this exceptional panel tonight. For those of you who are not familiar with Theater Or, we are a small nonprofit theater company. We don't have a subscription base, and we focus very strongly on 1 or 2 projects a year, perhaps. Sisters-in-Law, the run, is almost sold out now, but there are still some tickets available. And on the 8th of October, former Colorado Chief Justice Michael Bender will be our guest for a talkback. And although this hasn't been publicly announced until now, on the 23rd, Colorado Attorney General Phil Weiser will be in the audience and available for a talkback as well. And I do want to add that in our play, many of these topics are touched upon, and the audience reaction has been very interesting because most audience are very familiar lately with RBG, but they aren't familiar with Sandra Day O'Connor's accomplishments. And the discussions have been wonderful. And I think our director, who is listening in as a panelist someplace, has taken great pains in the production to show what both perceptions of the law were of each of these people, how they differed and how they found common ground. And it's really up to the audience to see, are these arguments balanced? Is one more than the other? Is one's accomplishment more or less? And these are some of the very questions the play raises. So I hope that those of you who haven't seen the play yet will come and see what all our panelists tonight were discussing, because it is absolutely fabulous preparation for the play. And if you still want to get tickets, you can get them at www.theateror.com. That's theater with an R-E. And best availability right now is the 18th or the 15th October, or the last weekend of the show, and scatter tickets in between. So thank you for this opportunity. And again, thanks to all our panelists for participating. And now back to Alan for the closing comments.
Diane, thank you very much. Again, this is the inspiration for this panel was the Sisters-in-Law play itself and the book. As I can add in the chat again, we have a landing page for the webinar. We have one more installation in our 5-part series. That'll be on October 20th. That'll be on legal reform going forward with a great panel from DU, including former Supreme Court Justice Rebecca Corliss as one of the panelists, along with Dahlia Lithwick, one of the foremost Supreme Court experts and journalists in this country. So a great panel there. We're eager for that close to this series. Again, I just want to thank our panelists tonight for the 4th excellent series we've had so far. Really appreciate their time, their thoughtfulness. The link is there for more information. Again, you can visit tatteredcover.com/event for future events in our very active series, both virtually and in person. Again, a pleasure to see you all this evening. Thank you all so much for being here, and we'll see you again soon. Thank you very much.